Alhamdulillahi Rabbil Alameen, Ar-Rahmanir Rahim, Maliki Yawmiddin, Iyyaka na'budu wa iyyaka nasta'in, Ihdina as-siratal mustaqim, siratal ladzina an'amta alayhim, ghayril maghdubi alayhim waladdallin. Thank you very much, all of you, mashallah, honoring us by attending this seminar. I'm thankful to Houston Muslim Bar Association of Houston, mashallah, Farah and Aslan, people are here. My name is Mahmood Maarfani. I'm a community service director of Shifa. Since last 30 years, I'm connected with Shifa, mashallah, from the very beginning. And I'm doing community services. We have the clinics, mashallah. So you have the flyer. I'm not going there. Now team is here, mashallah. They are so excited to be here. They want to serve community. This is very important. People from our community are coming forward to educate our people and coming to help. So I appreciate and thank you very much. This is something very, very important for all of us. Whatever their profession is, they should come forward and give back to the community. I invite Brother Salam, the president of Muslim Bar Association, now to take over. I'm not taking much of your time. If you need anything, please let me know. I'm here. Jazakallah khair. Brother Salam.
Hey guys, Assalamu alaikum. I think most of the people are here, so we'll start. Thank you for joining us, and I'd also like to thank Shifa for allowing us to be here in their space. And I'd also like to thank all the attorneys that came. You know, it's the weekend, and so it's an important time. And thank you to all of you for being here. Just to let you know what our organization is, the Muslim Bar Association of Houston. We provide development opportunities and education for attorneys. But another part of our mission is to also help our community and those in need. So we plan to do more of these education type seminars. There's going to be 11 of them, and this is our first one. So we thank you for being in our first one, and inshallah there's going to be more of these that will take place around our city. So the way that this is going to work, there's going to be 4 speakers. I'm going to give them all an opportunity to speak for about 15 minutes. And then right after that, there's going to be questions, maybe 1 or 2. There's only 2 to 3 minutes for questions individually. But if there's something you have that's more complex, you can meet them afterwards. I'm sure they'll stay for maybe 5-10 minutes just to talk to you. So without taking much more of your time, let me introduce our first speaker. Her name is Farah Ahmed. She's been practicing law in Texas for about 20 years. Her focus is related to contract, business, and real estate, in addition to family law and corporate law. She was recently appointed to the Texas Bar Committee for Civil Legal Services to the Poor. The mission is to make justice and legal support accessible to all Texans. So without much further ado, Sister Farah.
Thank you, Assalamu alaikum, and good afternoon. Okay, so I always have this interesting topic about wills and about probate. It's not a very easy subject to talk about kind of the end of your life. A lot of people have an idea that when I'm not here in this world anymore, it's not my problem. And I want you to look at it that it's not a problem, but it's something that you should take care of. In Texas, you have the right to have a will. And also as part of Islam, there's also the prospect of having a will. So it shouldn't be a new topic. And a will is only something that you want to see as instructions to your family members and to your loved ones about what to do with the things that you care for, with the things that you collect or the things that you own. So wills are definitely, like I said, written instructions. So when you have a will, it goes through a probate process, which means it goes through a court process. If you don't have a will, that is called intestate. And you know what? You still have to go through a court process. So the idea is having a will makes things very simple, and hopefully, most of the time, it's less costly, unless you do one that isn't done well, which has happened before. But if you do it properly and you keep it simple and to the point, it can be very effective and easy for your family to go through. So my thing is, try not, already you're passing away is a burden on your family. Don't add to the burden by not doing some of these very simple things. But in Texas, we want to go to the next slide, sorry. So this is like the overview of the will. I'm sorry, I forgot to tell you to change the slide. But anyway, intestate is when you don't have a will. So either you have a will or you don't have one. And my thing is you have instructions or you let the state decide. So you want someone that's a stranger to decide on how to disseminate your property, or do you want to have some say and control? Next slide. All right, so in Texas has done something very interesting. In 2015, they have something called transfer on death deed. Not a very attractive name, but we call it a TOD as a short form of that name. And this is a way for you to actually transfer real property. You don't need a will. So right now, everyone could fill this form out and follow the requirements, and you will take care of all your real property. For most people, real property is the most expensive asset they have. You know, your home or land, or even investment property. And so if you fill out this form properly, you can actually avoid probate. And what's more interesting about it is that it will trump the will. That means if your will says that you want everything to go to child A, but you fill out this other form, the TOD form, you want it to go to child B, which one do you think controls, the will or the TOD? An idea? It's gonna be the TOD, and it doesn't matter the date. So you could have done a new will after you filed the TOD, and your TOD, your transfer and death deed, actually has priority. So that's something very important. A couple of things, it covers residential and commercial, so for your home and investment property. It's very similar to like your insurance proceeds. If you have an insurance policy, you have to write down who do you want the proceeds to go to and upon your death, right? And so you can write different names, and the TOD is the same thing. You can write one name, you can write a multiple of names. So usually what happens is you have a husband and wife own a home. So the wife says, if something happens to me, everything goes to my husband. The husband says, if anything happens to me, everything goes to my wife. If something happens to both of us, it goes to our children. The only exception is that it goes to all your children equally. You can't say for some children you want them to get 43%, and for another child you want them to get 17%. So you have to kind of treat them all fairly. That's the only difference on that point. The other thing is, just because you filled out this form, it doesn't mean you've lost any rights to the property you have right now. You can do whatever you want with the property. So my idea is, you fill out these forms or you do a will, you only have to think about it once. Think about it once, you never think about it again. It's not something that I want you to worry about. You have to revisit, you have to change, you have to correct. And then if you sell the property, it basically voids the TOD. So that if you have a beneficiary, you have someone, let's say you wanted to give the house to your children, while you're alive, your children cannot make that an issue. They can't say, well, you know what, you've given us rights to this. We own some rights to this. We can use these rights for something. No. It only becomes effective when someone passes away. So that's nothing that you have to worry about. Next slide. The other interesting thing is, before we talk about this part, is on the TOD, when you fill out this form, you file it in the real property records. Yes, it is a public record, but somebody has to be looking for it. So when you fill out this form, you are not obligated to tell any of your children or even your spouse or anyone that you fill this form out and that you filed it. So if you want to keep it a secret to your family, you can. But technically, it is filed in the public records. So that if something happens to you, actually it's sitting there the same way your deed is there, right? The deed to your home is in the real property records. Well, this document will also be sitting there. That's why the change of title is done automatically. There is no wait time. You don't have to go to court. You don't have to do anything. So the person who has the right to that property, immediately they can sell it. They don't have to wait 30 days, 60 days, nothing. So it's a very smooth transfer of title. One of the advantages of a TOD, so even if you have a will, a lot of attorneys that do wills, they will also do a TOD, a transfer of death deed. And the reason why is Medicaid. That's the number one reason. I'm not saying everybody here is on Medicaid or should be on Medicaid or may be on Medicaid, but let's say it could happen. So in Medicaid, Medicaid has a right to be reimbursed for expenses from your estate. But if you do the TOD, at least your real property is protected from the government coming in and saying, we want you to repay us on these benefits that you've taken. You can also make changes to the TOD, right? You can cancel it, you can refile a new one after you cancel the old one. And the cancellation procedure is also very specific. So you have to specifically file one. If you change your mind, you have to file another document to properly cancel it. And then we do have forms. So even on my handout, I have an email. If you want a form emailed to you, I will will definitely email it to you. It is available on many websites. We do recommend that at least, yes, you can fill it out yourself, but at least have a lawyer look it over, because there are some errors. If they are very material or important errors, then your TOD will be ineffective. So you have to do all this work and it doesn't work the way you expect it to work. Next one. All right, one thing that TOD won't do, so you're thinking you're filling out this form, that it's gonna protect you from creditors. That's not gonna happen. So if there's a mortgage on the property, the people that you want them to be beneficiaries of, they're going to be responsible for that mortgage or loan or lien. So don't think that this is a way for avoiding creditors at all. And then, of course, it definitely has to be filed. If you fill it out and you just keep it in your desk drawer, it is ineffective, as if you never filled out that form. It has to be properly filed, and it's filed in the county where your home or your property is in. Next one. All right, so the TOD here, you can fill out the form or you can develop your own one. Attorneys have their own forms also. So definitely it has to be in writing, all right? And then you have to state who do you want to transfer the property to. The legal description is very important. It's not just the mailing address, but it's the same legal description that you would have, let's say, on your deed. So it's very important to copy and paste that. And then again, you can list multiple beneficiaries. I talked about, you don't really have to tell the beneficiaries that you've done this. You need to file it with the clerk of the real property records. Yes, you can revoke it, you can cancel it. And interesting, I know we have Joseph talking about power of attorneys, right? So I don't know if you knew about this, but power of attorneys cannot fill out the TOD. You're going to have to do this yourself, right? So the key thing is to try to do it when you're in good health. This is not a good idea to do this when you're in poor health. So these are things that you want to think about doing right now. But if you want to cancel and revoke it, interestingly, anyone that you've given a power of attorney to, they can cancel it for you if you're not able to do that, okay? And I think that's it. Yep, that's it. All right, thank you.
Thank you very much.
So let's take some time for questions.
Oh,
Do you have
is there any
questions?
1 or 2 questions that you have? I'll also be here later if you think of some questions.
You don't have any questions?
All right.
Yes.
If you have a trust set up, then is that over, like TOD, or which one would be there?
Well,
You
I
have a
mean,
trust already.
with the trust, you've already transferred title to something else, right? So, yeah, then you won't be able to do that because someone else is holding title. So right now, this is someone that holds an individual title to land or property. What's interesting is you can also list a charity as a beneficiary too. So it's not just only for your children and your family members, but if you want to give that property or home to a charity, you can also list a charity as a beneficiary. Yes.
Since your property is a joint property, your residential property is joint property.
Yes.
Do you write it for your own portion or for your spouse as well?
Well, the TOD, that's a very good question. So a TOD will only transfer what you own. So you're 50% because we're in community property. But the way the forms are written, they're really nicely written. They're written really for a joint ownership or for a married couple. So immediately both the husband and wife will both fill out the TOD at the same time, and you have to have it signed and notarized and also witnessed to.
So both of the spouses has to sign or one can as well?
Well, if only one spouse signs it, then it's only valid for their portion. So the way they have it is both have to really sign the document and have it notarized and have it filed. So it's very easily done. It's like a joint will. You kind of give everything to one spouse and the other. It's a good question.
If somebody is a spouse, is only one spouse left, and they can sell the property or not, if it's a spouse give the right, and after that, the one spouse is left,
Yes, if the TOD is written and they're the beneficiary,
yeah,
they can do whatever they want with the property. They don't actually have to abide by any of the terms in the will. Right? So it's a completely separate, independent. I'll give you an interesting case that happened that I got. Is a father, a single father, his wife passed away. He had his most valuable thing was his home. And he had 6 really wonderful children. And so this is where a TOD can have power for good or not good, depending on which side you are, right? It is a very powerful document. It's so new that even some of the judges didn't even know about it, that I had talked about, that it trumps a will. It's more powerful than a will. So he has 6 children. So in his will, he left everything equally to 6 children. Well, one of his children took care of him when he was not feeling well before he passed away. And he filled out a tod for that one child to get the whole house, right? And so after he passed away, that child had ownership of the house. Well, the other 5 children called me and said, what about us? We're in the will. We've been ignored. And they actually have no rights at all. That tod was more powerful than what he had written in the will.
As I had my property, like my husband is not here, he gave me power of attorney, so I can do my own legal things.
He gave you power of attorney to represent him? Yeah, okay, so like for the tod, I was saying you cannot fill out the tod for him. He would have to do it himself. Okay, I think what we'll do is we'll probably move on to the next presentation. Thank you for your questions. I'll be here a little bit later to answer your questions. Thank you.
So we'll just do it at the end. All right, so the next topic is going to be general overview of marriage in Texas, and it's by Relay Oladapo Jimo. I hope I said it somewhat okay.
Yes, you did.
Okay, she's an attorney licensed here in the state of Texas since 2003. She received her law degree from Thurgood Marshall School of Law. All right, and her primary practice is in family law in Harris County. Okay? So,
Good afternoon, assalamu alaikum. Maybe I'm the anomaly. I was raised in the faith, but I don't practice the faith anymore. But wherever there's God, I go. So thank you for having me. I'm originally from Nigeria, and like you said, I've practiced family law for about 16 years. And I practice primarily family law. Family law encompasses a whole bunch of issues. We have marriage, we have divorce, we have adoptions, we have custody battles, we have conservatorship, we have possession and access of the children. But I was asked to keep it very basic. I was hoping that there will be younger people here so we can talk to them about what they need to consider when they want to get married. I'm sure the older folks have children that they can take this information home to and tell them that these are the things that you want to consider when you fall in love and you want to form a union with your partner. So the first thing that I will talk about is how do we get ready for marriage in Texas? We discuss a whole bunch of stuff. We talk about financial assets. We talk about, some people when they want to get married, they already have, real estate, or they have a significant estate prior to getting married. In Texas, there's something called separate property, and then when you get married, what you accumulate is, is presumed to be community property. Separate property and community property don't necessarily mix. Now, prior to getting married, you can actually agree with your partner. You can have a prenuptial agreement. You can say, whatever we accumulate during our marriage is going to be deemed separate property or is going to be deemed community property. So this is one of the most important things that we need to talk about prior to getting married. How do we deal with our financial assets? And then we also have to talk about parenting. With marriage, there's a presumption that we're going to have children. Sometimes, we marry outside of our cultures. Sometimes we marry outside of our countries of origin, and parenting is different. Just because you have a different parenting, a different way of parenting, doesn't necessarily negate the other person's method of parenting. So prior to marriage, we have to talk about, okay, we're going to have children, and how are we going to parent these children in such a way that we don't create conflict, or we are in agreement on how to raise the children. Then also, we have to talk about religion. Everybody assumes that we're going to marry a person from the same religion as ourselves. Well, that's not necessarily true. Sometimes a Muslim will marry a Christian. Sometimes 2 Muslims will join themselves in marriage, and somewhere along the line, the wife or the husband will decide that, I'm going to change faith, and I'm going to become, a Christian, I'm going to become a Buddhist, I'm going to become, what have you. We have to decide, the children that we are going to conceive, how are we going to raise them, in what faith? It's a very important question, because sometimes, the father says, and this might be a cultural issue, the father says, I'm the father, and I get to tell the children, what religion they should practice. And then the mother says, well, from another cultural perspective, I get to tell the children what religion they practice. So this, once again, is a very important conversation that we have to have prior to marriage. There's conflict resolution. Sometimes conflicts arise in a marriage. And most times we go to a religious leader who is not necessarily versed in conflict resolution. Well, in Texas, we have so many licensed marriage counselors and so many therapists out there who can actually help us to, resolve the conflicts in the marriage. So I have 5 things that I listed up: financial assets, communication, parenting, religion, and conflict resolutions. These are the conversations that we have to have prior to getting married. Now, what are the legal marriage requirements in Texas? Ideally, you have to be 18 to get married in the state of Texas. However, if you're under the age of 18, you either have parental consent or you have, judicial consent. There's some people who are not quite 18 who get emancipated prior to them reaching the age of majority. So when the court emancipates you, then you are legally allowed to marry. Or if your parent says, yes, you are 16, we will give you consent to get married. But you need either judicial consent or parental consent to get married. And then when you obtain a license, there's a 72-hour waiting period. It's like a cool-off period. People fall in love and they're so excited and they want to get married. So the 72 waiting period is a cool-off period. You've got the license, go home and think about it. Do you really want to get married? It's a short period, but sometimes that 72 hours is enough for 2 people to decide that maybe we're not really in love. Maybe this is just infatuation, or maybe we're not really meant for each other. So it's a cool-off period in the state of Texas. There's an exception to that. If you're in the military and you're on active duty, the 72-hour waiting period is waived. Or if you work for the Department of Defense as a contract worker, the 72-hour waiting period is also waived. You can also complete a premarital education course, and that will also waive the 72-hour waiting period for you. Who can conduct a marriage ceremony? A lot of people can conduct a marriage ceremony. We can do an ordained minister or a priest. We can do a Jewish rabbi. We can do an imam, an officer, a person who's an officer of a religious organization who is authorized by the organization to conduct a marriage ceremony. We can do a judge. We can do the justice of the peace. Any retired judge or magistrate of a federal court in Texas can also conduct a marriage ceremony for you. There's also something called a proxy marriage in the state of Texas. Not all the states in the United States allow for proxy marriages, but there's some instances where one party of the marriage is not able to be here in Texas. There's certain reasons for that. Maybe a party is in another country and has visa, is not able to come into the United States, maybe is not able to obtain a visa, or has a travel limitation on that person. Then somebody else can stand in place as a proxy for that person to get a marriage. Also, if you're a member of the United States Armed Forces, are you on active duty in another country? A third party can stand in place as a proxy for you to get married in the state of Texas. And also if you're in prison, so a lot of times we have people who are in the penitentiaries who are not able to come out to actually attend the wedding ceremony. They can actually appoint a proxy to help them get married. In the state of Texas, there's no discrimination based on gender, religion, national origin, and most especially more recently, there's no limitation on gender. There's been case law that's come out that says that you cannot restrict marriage between a man and a woman. So there's no discrimination based on your gender or your religion or your national origin. Anybody can get married in the state of Texas. And that is all I have. Thank you for having me. If you have any questions.
Great. Very good.
Thank you. Any questions? Yes, sir.
There's a divorce case, and the judge granted the spouse the house, but the other is in it.
Okay,
and the children are grown up.
okay.
What's the case?
Okay, so you're saying wife, okay, so the wife, are you asking about the legal implication? Is that the question?
Yes.
Okay, so basically the wife has a life tenancy in the house, okay? So, the spouse, so when a party dies, the spouse, and Farah, you can correct me if you can, the spouse has a life tenancy for the duration of that spouse's life to live in the community residence. So yes, it does happen. The spouse can live in the house even though it is separate property. It's a life tenancy because it's their, what's the word?
Unless they fill out a card.
Except they fill out the tone, there's a word in real estate when you split. No, not community. No. Homestead. Thank you. If it's your homestead, so the spouse has a life estate in the property, yes. Any questions?
You mentioned who can conduct a marriage ceremony?
Yes, sir.
Does it have to be licensed by the state or any person?
Yes.
They have to be a certified imam or something?
Not necessarily, you don't have to be, so the religious leader don't necessarily have to be licensed. But if you're not a religious leader, then you have to be someone who is licensed by the state of Texas to conduct marriage ceremonies. Yes, sir. Yes, sir.
In proxy, in terms of the spouse or going to be spouse is not in the country, how does she or he get the paper for the proxy?
So it could be a power of attorney. You can give the person a letter saying that I grant you the permission to act as a proxy for me. So it's kind of like a power of attorney. You can go to the U.S. consulate. Most U.S. consulates have notary publics, and you can notary.
In Houston. His work is based in Chinatown. He speaks Mandarin and Arabic as well as English, I guess.
That's unique.
He entered in Harris County Military Corps 3 during law school, so something he's had a passion for doing for a while. So without further ado, go ahead. I'll send you Part-1. All right. بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم على نبينا محمد وعلى آله وصحبه أجمعين. السلام عليكم. So, thank you Arslan for your introductions. Thank you Farah for organizing. Such a great effort. As you said, all I do is wills, trusts, and probate. Probate is distributing stuff after you pass away. So your family helping distribute stuff after they pass away. That's all, simplified definition of probate. And like I said, I worked at the probate courts, just like you have the divorce courts, the criminal courts. You have something called the probate courts. You got 4 of them in the middle of downtown. So I worked there for a little bit. All right. So now when you do a will at a lawyer's office, usually a good lawyer is going to have more documents on the side that you sign too. That's what I'm talking about. I'm talking about the side documents, right? Just over there, they're called ancillary. Ancillary is a legal word for side. Side estate planning documents. The first one, okay, I'm going to talk about 7 of them. The first one is called a power of attorney. Now I know the text is small, but that, don't mind that. I'll explain just what you need to know. A power of attorney is a piece of paper that, where you name somebody to have power on your behalf, right? So say I'm going to be real busy, I'm going to be overseas, but I want my wife to go ahead and access bank accounts and sign stuff on my behalf. So that's what we call the power of attorney documents, right? So it's very important when you do that, when you do your will and you devise your estate, in your will, make sure you have your power of attorney on the side. You name somebody just in case you get incapacitated. So it's not effective immediately. Of course, you can decide to do that. Rather, you can say it's effective once I'm incapacitated. So once I'm in the hospital, for example, I can't talk, then that's going to help you. That's, say you have a house you're renting out to others, right? And who's going to access the bank and collect money from their tenants and all of that? If you named your wife or your husband, you're in good shape. The next one. So that's the power of attorney. The second one is called a declaration of guardian of the estate. What this is here is you are naming somebody after you pass away, or rather when you get incapacitated, so they can manage your estate. Okay? They can, for example, bring a lawsuit on your behalf. right? They can manage your everything that has to do with money. That's what this is. You're naming somebody to take care of your money just in case you get in the hospital in a vegetative state and you can't talk. This is what this is. Okay? So you can have a separate document naming somebody to take care of your money just in case you're in a vegetative state. So that's what that is right there. Okay? Now, this one here is very important, extremely important, especially for the Muslims. As Muslims, if we are in the hospital and we cannot talk, somebody needs to make the decision, are they going to pull the plug or not, right? This paper here, medical power of attorney, you name the person that you want to make that decision for you. So if, for example, if you're in a vegetative state and you want your wife to make that decision or your husband, you write their name. And so when something happens, God forbid, that person will have authority with that paper with the doctor and talk to the doctor and say, hey, do the surgery. Actually, don't do the surgery. Pull the plug. Don't pull the plug. You put it all in that document, right? Actually, there was a case, unfortunately, they didn't have this paper. And the wife and the mother of the person, they kept arguing and arguing for about a year. Pull the plug, don't pull the plug, it's halal, it's haram, And they had this debate, and then eventually he passed away, after a year of debate. So you don't want to cause confusion in your family, just put this one here, make it easy. Next. All right, this one here is also very important. It's called Advanced Directive to Physicians, also called the Living Will. This here is a paper where you tell your doctor if you want him or her to pull the plug or not if something happens to you. Okay? Now, this means if I sign this paper and something happens to me and I'm in the hospital and I'm in a vegetative state and I can't talk, and my wife, for example, takes this paper to the doctor and the doctor reads it and says, okay, he told me if I am in an irreversible condition and there's no point of return, then pull the plug. That's what it says in there. And if I, that's what it says, among other things. And so then the doctor will pull the plug because you told him to before you became in that state. And actually, believe it or not, less than 24 days ago, or 20 days ago, there was the first Islamic bioethics conference in Houston. They held it in the Baylor St. Luke's. And he knows what I'm talking about. There was a sheikh there who was also a physician. Okay, Sheikh Basim Hamid, who was affiliated with MJ as well. They spoke only about this, only about Islamic bioethics, pulling the plug, organ donations, what's halal, what's haram, what's in the middle, permissible, you can do it, you don't have to do it. They said this one here, this is halal to do the advanced directive, to sign it and say, hey, if I'm in an irreversible condition, I'm not coming back no matter what, pull the plug. They said that's halal. So definitely, as a Muslim, do it. Avoid the conflict between your family. And the HIPAA release here, very quickly, is a document you sign while you're alive here, saying if something happens to me,